Talk and live on
Everything.
everything live. Get into this. Usually it means that's like done. Hi everyone, my name is Joseph,
Hi, my name is Gabby.
and today we are gonna just do what we normally do on these lives. We're gonna be talking about two big news about immigration as well as one success story. The success story is about an E2 cleaning business. Somebody invested money in the US, started a cleaning business, got a visa, and is able to stay here indefinitely. It's a French national, so we're going to go over that success story in the end of this show. In the beginning, we're going to be talking about two news that's happening and what we're seeing on the ground and how it's impacting people. The first one is about ICE detaining people at the airports for people who have overstayed. We're going to dive in deep on it, and we're going to talk about it and a lot of misunderstandings surrounding that. The second news we're talking about is at USCIS interviews and what USCIS officers are drilling in during these interviews that we've never seen before. How they're using AI, what's happening at the interviews, and a private conversation we had with a USCIS officer about their recent trainings. And so it's really, really good, really informative, and we really want to share that with everybody. So that's going to be the entire span of the hour that we are here. As always, feel free to ask questions about your case, about your friend's case, doesn't matter, right? Ask your case. Galen here is going to ask your question for you, and we will answer to the best of our ability. And we're going to do that for the hour. Okay. Yep. Get ready? Okay. So the first news we want to go over is ICE detaining people at the airport. And there's a New York Times article about that. We're seeing ICE officers have been stopping different people. And how this is happening is because when you board a flight, with the name and information you provide, the TSA writes everything out. And once they write everything out, ICE gets a copy of that. And once ICE gets a copy of that, they double check it with your I-94 record. It's almost instantaneous. AI is able to spit it out right back to them. And at that point, ICE is making a determination. Do they want to go to the airport and stop you? And we're talking about domestic airlines, right? So you're flying from California to Hawaii, from Hawaii to, Alaska. It's a domestic airline. But still, there's ICE agents at every single airport, and they could see. And it's up to them to make a decision. Do they want to go and detain you before your flight or after your arrival, right? Because they see everything. A lot of people are saying that this is incredibly not right. A lot of people are saying they even though it's an I-94 expiration, they've already filed an adjustment of status. Why are you still detaining them? And in the past, domestic flights, ICE doesn't spend time doing that. It's usually only on international flights if there is a problem or if they're crossing the border and there's a problem. Domestic flights has never been an issue. Last year, we saw this also with DACA recipients. People who have had valid work authorizations, people who have been here for forever, and now they even have a DACA approval, and yet being stopped at a domestic terminal. Now, what ICE have repeatedly said in the past year now is that just because you have authorized stay does not mean you are not removable. In other words, I can still pull you into proceedings. I can still put you in removal proceedings, even if you have DACA, even if you have a pending adjustment of status application. And the reason is because your I-94 expired. The moment your I-94 expired, the moment you don't have official status in the US, then you are in limbo. You have authorized stay to file a case with USCIS to potentially get a green card, but who's to say USCIS will guarantee approval? So I could put you in removal proceedings. That's ICE's line of reasoning. A lot of lawyers, a lot of clients, a lot of people push back against this rationale saying, no, you've never done that in the past. People have authorized stay. You shouldn't do that. ICE pushes back saying, well, we chose not to do it in the past. We've always had the legal authority to do it, but because of funding, because of various reasons, we didn't prioritize this area of enforcement. If you're here, you have no criminal record, we weren't focusing on domestic airline travel. But now we can. And so that is what we're seeing. That's the line of argument that they're pushing. DACA removal, will you have authorized stay? Sure. But that's only deferred removal. We can remove you at any time should we choose. You could still win it at court, but that's up to the judge. My job is just for enforcement. So basically, starting from last year till now, the enforcement arm of immigration, ICE, they have a quota. And now we're seeing this news happen. Is it happening at every single airport? I don't think so. From the way I'm reading the article, from our own clients traveling, from a lot of things we're seeing, I don't think they're enforcing it in mass, because if we're truly calculating how many people who have I-94 overstays, who are pending 45 adjudications, who are DACA, who are traveling internationally, that's going to be in the probably tens of thousands every single day. We're not seeing tens of thousands of people being arrested every single day, but a few cases being detained and then being released is enough to cause this New York Times article to create a stir. Is it a political theater? Is it to drive fear into people's hearts? You know, I mean, I'm not here to say exactly what the intent is, but ICE's authority have expanded. ICE's funding have expanded. Their quota have been set. And is this a threat for people who are in a pending state of 45 adjudication process? Yes, right? That is, I think, the scary thing for a lot of people. And it's confusing because I came in legally, I filed adjustment of status. In a few months, I'm supposed to get a green card. And this has been always done in the past 10, 20, 30, 40 years. How come now ICE is detaining me and stopping me and putting me in removal proceedings? That's, again, they've always had the authority. They chose not to exercise it in the past. They didn't have the funding in the past, but now they do. And if you are the unlucky individuals that are getting picked up, that are putting in proceedings, that's sort of the state of reality. That doesn't mean everybody's going to be locked up in detention for months and months. It could just mean they detain you, bring in, giving you an NTA, and now you have a notice of intent to appear in immigration court and a USCIS case going simultaneously. And now you have to go to immigration court to try to close out this case and transfer it back to USCIS or vice versa. And we've done that, right?
Yes.
Gabby and I, we've done these type of cases, but now you're just in you have an extra step to do, right?
Yeah, Gabby, I'm curious, what was your reaction when you first heard this news?
I honestly was not surprised. And I think it's just, you know, with the current administration, anything can happen. Any day that you wake up, you have news about, you know, something going on or a new memo or a new policy. But what was interesting is that now, even if you have a pending case, they are still detaining people, which, you know, it just complicates the process, but it also adds a lot of like pressure, I think, both on the government and the public, right? Like the government now needs to process more people in proceedings. There are a lot of more resources that are wasted. And what if you go to court and the judge looks at it and says, why are you even here? Like, you're already fixing your status. I'm going to just close your case, just go back and continue your adjustment of status, right? So then you just wasted time, money, and, you know, like, gave someone a headache that was not necessary. So I think I was not surprised, but it's just that seeing things from my perspective, it's like, I think it's unnecessary, but the law is the law, you know, and they are trying to, at the end of the day, I always think this is a person doing their job. You know, they are there to do a job, and it's hard to understand that part, but it's the reality. You know, they are getting paid to do something. They are given instructions, and they have to do what they have to do. So I think, just being very diligent on, you know, not traveling, I guess, now, if you have a pending case, or consulting with your attorney before you make any traveling plans. I think it's the way to go right now. I actually wanted to ask Joseph, so what's the difference between authorized stay and lawful presence? Right?
So the people who are being picked up is their I-94 have expired. So maybe you come in as a tourist visa, you're granted 6 months of I-94 authorization. If you want to continue to stay, you need to file an extension, or you need to change the status to become a student, and you have an extra couple years. But that I-994 controls how long you are lawfully present, and within that time, you can change status to another status. You can file adjustment of status. You can do a lot of things. That's why we have a lot of clients who on F1 they change to H1B status, and then while they're on the H1B status, they file for adjustment status to get a green card through work or through family. But usually we still tell all our clients, still continue your H1B. Don't just give it up immediately. Technically you can, but just to be safe, keep it. If you're still a student in the F1 status, continuing being a student, continue to pay that tuition until you get your green card, and then right, we've always said that, and that I-94 controls your lawful status. But you could stop, and now your I-94 expires, your adjustment of status is pending, you're authorized stay because potentially you could get a green card. But if an ICE officer shows up and says, oh, your I-94 have already expired, your 45 is pending, well, just in case, I'm still going to pick you up, put you in immigration court, and now we'll let the judge decide if they want your case, if they want to adjudicate your case, or they want to close the case and give it back to USCIS. But I did my job because I saw somebody who might be deportable in the future, so I'm just going to pick them up now. So that's kind of their kind of rationale, right? If they're trying to meet that quota or anything like that. Okay.
Yeah, Enron says, Enrod, 1 week before his or their citizenship ceremony, they were detained at the airport for 3 hours coming back from Mexico.
Wow.
That's
3 hours coming back. So what happens is you went to the primary, the officer looked at your situation, they're quite confused, they have a lot of questions, they send you to secondary. In secondary, you wait there in the room for maybe an hour before they get called up, and then they heavily question you. And so we see people get pulled into secondary all the time. And a lot of people who are on green card holders or visas, they once you go to secondary, you're almost guaranteed to have to go to secondary forever and ever, right? You could use the DHS trip to try to eliminate that, but that's once a year, you have to keep on doing it, but it is extremely problematic. One thing that most people don't know about the immigration system in the United States, a lot of times is we give you the benefit of the doubt first, arguably, and then once you get in trouble, it's going to be very, very difficult to correct, right? Whatever's in your system will forever stay in your system. And so it creates a situation where people who gotten their visa relatively easily, they think everybody can get the visa really easily. And then once something happens, they think, okay, well, let me just correct it and get another visa. And it becomes almost impossible to get another visa, right? And so that's sort of the way the US system is set up. Now, sometimes I didn't do anything wrong, but your family member came to the US before you, and then they overstayed, and now they applied for asylum, and now that doesn't look good on you, and so you can't get it, right? So your actions impact other people, and other people's actions impact you. That's sort of the nature of the immigration system we have.
Would you recommend that they pull their file from USCIS and see if there is anything that might have triggered that detention? Or
Well, they already got a citizenship, so they're probably fine now. But secondary is quite common, and so maybe this is the first time they got pulled in, and so they're really shocked by it. But plenty of people get pulled in.
So if ICE picks you up, are these facilities, is it like going to jail, basically? Like they take you to essentially jail?
When ICE first picks you up, they don't directly take you to a detention center. They take you to their field office to process you. That's where they double check in more detail what is your actual status. Now, sometimes if you are already in a prison, in a jail, at the sheriff's office, after you serve your time, the jailer already worked with ICE and USCIS to determine your status, and they know you're unlawfully here, and they know you're removable, and they know you're deportable. Then when ICE picks you up directly from the sheriff's station or a jail or a prison, then they directly take you to detention center. But if we're talking about airports, churches, hospitals, schools, off the streets, off the car, right? Just typically, they don't directly take you to a detention center. Typically, they take you to their field office, and then they double check everything. And sometimes you might be there for a day, 2 days, or 3 days. And then once they double check exactly your status, the first thing they're supposed to do is determine if they are willing to release you on an ICE bond. So if you don't have mandatory detention, they could make you pay for a small bond and then you leave. But they give you an NTA, a notice of intent to appear, and now you have to appear before court at a certain date, 3 months from now, 6 months, a year from now. But they did their job, right? They caught you, they put you in the proceedings, and now it's up to the court, right? That's if whatever reason they caught you, it's not a big deal. It's not a mandatory detention, so they put you in. Sometimes they in their discretion, they determine that they should put you in detention, but detention centers are full all across the country. They don't want to waste a resource on you. You have strong enough equities. You're not a public threat. They make a determination. You can still get a bond and leave. But as we're seeing, detention centers are being built out across the country. So much of the billions of dollars that they got last year and this year is to expand the real estate for detention centers to pay the contractors. So once these are built out, there's more beds. A lot more people are going to be going in there. And then once you're in detention center, then you can appeal and request a judge to give you a bond hearing, usually in about 2-3 weeks. And then at the bond hearing, then you can get a bond, then you can leave. But if the judge denies you, then you're staying in there for the remaining of time. Now, how long do people stay in detention centers? It could be 6 months, it could be a year, it could be a year and a half. Is detention center like a jail? Well, some say it's a lot better than a jail because a jail is a lot worse. Some say detention center could be worse than a jail because you're constantly being transported left and right and you don't have a routine. So,
any update on the 75-country pause? When will it end?
I have not heard of any updates on it. I still think it's gonna continue all the way through till the end of the administration.
Yeah, it's interesting, right? Because it was initially for public charge, right?
Yes.
And now they've released new public charge rules.
Right. So let me explain. The 75-country pause is for the consulate. So if you are about to receive an immigrant visa at the consulate says, yes, we approve everything. However, because of this pause, we cannot give it. And the reason why the pause is there is because the Trump administration thinks the public charge rule is too lax, both in the US and overseas. So it's easy just to go after the low-hanging fruit. So the 75 countries the Trump administration has determined is the poorest of the 200 plus countries. And so we put a pause on all of their immigrants. Okay, so that's that prejudice. The newest rule that got released last week that's going to go into effect in September, I believe, is that applies to the U.S. So before, the 75 country doesn't apply. The U.S. one applies now. And so once that goes into effect, they potentially will modify that and then take it and apply it to the 75 countries. And then the 75 country people will all have to go back to interview and meet the new higher standard and then maybe get the visa. But again, I don't foresee that happening anytime soon. But we'll see. Maybe I'm wrong. Maybe next year it will be lifted.
So that means the public charge that applies to the U.S. domestic cases, the adjustment of status, essentially. So anyone applying from now up until September 16, when it goes into effect, will be adjudicated based off of the current public charge rule, correct? So the new public charge is if you file after September 16th, then the new rule applies. So
with that being said, I wouldn't think too much about the specific timing of it, just because once a rule goes into effect, USCIS still have to train all of their staff on how to adjudicate these cases, because this new rule essentially is blowing the old rules out of the water and saying it's all discretionary practically. And so they have to write out template denial notices. They have to really train, because they don't want one officer approving all the cases and another officer denying all the cases. Then it's just willy-nilly all across the country, right? So from top down, there's going to be a lot of training. So naturally, the 3 months, processing, it's a lot of training. Just like what we see in the past couple of years, a lot of times when a new memo goes out, actually implementing and seeing the first request for evidence or denial comes about 6 months after the official rule. So, cases now, cases after September, start preparing with a higher standard in mind and double or triple the amount of documents you can prepare to show that you're not a public charge, right?
And LPR received a notice to appear for alleged fraud or misrepresentation, tried to depart the U.S. after that, got questioned extensively by CBP during the outbound inspection. Will ICE arrest upon re-entry?
Let me repeat the situation. A green card holder got a notice of intent to appear in immigration court for fraud and misrepresentation, so wanted to leave the country. Was questioned extensively by a customs officer on the flight to leave. So that only happens in a very few situations, but for example, I know what Puerto Rico, that happens a lot in Puerto Rico, and a few other where there are CBP officers stationed. That is for sure on the record, especially if you're questioned by CBP officer. Upon re-entry, I can almost guarantee, I can't say that, but I have seen so many people get detained for over 8 hours at secondary. One thing is because CBP officers, the customs officer, will already see you have a removal proceeding. So it's out of customs hands. The first thing they have to do is they see a removal proceedings, they see an NTA, they see a court appearance, they have to pull you to secondary. They have to call ICE and say, hey, this individual has a court hearing. Are they inadmissible? Are they deportable? Do you want us to let them in? Do you want to pick them up? Do you want them to go through bond proceedings? What do you want us to do? And it's up to ICE to make that call. And then after ICE determines it, then the customs will determine the second thing, right? So if ICE determines, hold them, we're going to pick them up and we'll take them into the detention center and then they can apply for a bond, that's one way to go. If ICE says, we're not going to pick them up, you decide, then the officer can think, well, do I want to let them in as a green card holder and just let them just directly go to a court appearance, or do I want to parole them in? And if they are deemed inadmissible later on, then we could deport them. And with the newest Supreme Court ruling that just happened in June, a lot of CBP officers might say, well, I'm just going to parole you in, right? So if ICE says we're not picking them up, CBP says, well, for our protection, we're just going to parole you in so we don't get in trouble. But either way, you'll probably be in secondary for over 8 hours.
Waiting for 751 waiver. It's been 48 months now. How much longer will it take, and what would be the outcome?
Outcome is hard to say. A lot of people have been waiting that long. If it's a good case, you'll get approved. If it's a bad case, could be denied. But that's pointless, me saying, right? So it obviously depends on your case. But waiting the 48 months is not completely abnormal. It is a bit long. So if you could file for an N400 to push them, that will be one strategy. But I mean, it should be any day now. Next 6 months, I would say.
Yeah, possibly about 3 to 6 months, and then double check with the USCIS website case processing times to see if you are already outside of normal processing time. Then you can file an inquiry, contact the field office to kind of like remind them that you're still waiting. But it's pretty common nowadays. Yeah.
Can you have an attorney at secondary inspection?
Depends on which port of entry. So, for example, airports, the attorney can't go into the airport because it's an international airport, right? So I've tried, couldn't, sorry. If you're flying with the client, right? So I've seen that happen. Overseas attorney fly with the client on the same flight, fly over. But will the CBP officer allow that attorney to go with them into secondary? A lot of times they don't even allow family members to enter secondary, right? So that becomes a different situation. Will the attorney? I've done it plenty of times at various ports of entries, and the way I do it, a lot of times I say the client needs translation. I'm only here to provide the basic facts. I'm not here to argue with the CBP officer. The client situation is very delicate, very confusing. In order for the officer to make the clearest adjudication, I need to provide a couple things. Sometimes I do it before the client even comes. So I pre-arrange it. Like, here's the situation. This client is extremely complicated. they're coming regardless, so might as well let me spend a minute explaining it to you, and then you can come, and then you can talk to the client. I'll step back, and if you need me, I'm here on standby, right? So that's usually my method. They like that, I think. Lots of CBP officers, okay, I'll give you a minute, explain everything, and then I will decide what to do, right? Nobody likes to argue with an attorney, right? And most attorneys just argue with them all day, every day, right? And so usually that's kind of my role. Translator, explanation, packet, all the documents. I'm on standby if that way the CBP officer, if they can't communicate, they don't have to call a translator, right? Because if they can't, they need to make a determination. A lot of times they have to wait for a translator to be called in from nearby. Now at LAX and JFK, they have translators on standby from all languages, but still it's a pain in the butt to call the translator in. So and other ports of entry, they don't have a translator, so what are they going to do, right? And so that's usually how I go about doing it.
I like how you always frame it as like, I'm making your job easier, right?
Oh, yeah.
Like, I'm just trying to help you out.
Yeah.
If it helps the client, well,
Right. It's important, Our job is to help you, help us, help you. And the thing is, that's why our nonprofit, part of our nonprofit goal is make immigration better. Because a good system, a valid entry, a right judgment, it should benefit everyone. If the client is a green card holder that can come into the country, the green card holder is going to pay taxes, is going to stimulate the economy, is going to spend money, right? And the CBP officer making the right judgment, letting them in, helps America. A wrong person coming in harms America and harms the officer's reputation because they signed off on it, and it harms the client, right? Well, maybe it doesn't harm the client, but like a good choice should be beneficial for all parties involved.
I have an EB3 interview in December. I'm here, and my interview is in Jordan. Should I cancel my free health insurance for my kids?
Oh, I'm assuming your question is the public charge rule now not only looks at the individual, but also looks at the entire family. So your question is, your assumption is, if my kids are still having free health care in the United States, will the interviewer at the consulate or in the US look at my case and say, no, I think you are a public charge because your family have received benefits, therefore you don't have enough money to support them, and therefore you are a public charge. Historically, all business type immigration cases have never, I don't say never, but it's almost rare, right? Probably 1 out of maybe 10,000 business immigration cases have been challenged or denied on public charge. Why? Because by the very fact of business immigration, the US needs you, they're giving you a job, and you can fulfill everything, right?
Additional fact pattern, their salary is $130,000.
Sure. So salary is high enough, but children use benefits. Will they deny me based on public charge? The answer is nobody knows right now. But historically, for business type cases, that hasn't been the case. What are we recommending our clients these days? Double and triple the requirements, right? If the requirement was here, the government is supposedly making it harder, making it discretionary, but you don't know exactly where the line is, right? In the past, if it was here and if you were here, you passed, right? Very, very few people get denied under public charge in the past, especially if you meet the requirements. But now, you don't know where the line is. So double it or triple it, right? So a family with kids. So the way I would think about it is EB2 historically hasn't been a problem. So you pass one green light. 130,000 salary, depending on what city you live in, depending on how big your family is, probably meets the poverty guideline. And so 2 things meets it. But you have one negative. Your family member have used benefits. So, 2 minus 1, now you're back at 1. Can you use anything else to improve it by 1, right? Now, if you stop the benefits, but they still look in the past,
Right.
you might want to do the other arguments. Look into the future, because the public charge is about the future. If they did use benefits, they were under 18. They're about to be 18. They're about to be 21. They're about to make their own money. They will not be using that
Public
anymore.
benefit. Mhm.
You have a lot of assets, right? Before, you as a EB2, EB3, going to the interview, there's no way you had to show your stock portfolio, your 401k, your retirement benefits, your Bitcoin account, because that wasn't relevant. But if you have that, well, that gives you another point, because I have enough assets to support, and we won't be using it, right? And so that's kind of my analysis, right? Just triple the amount, and you should be safe. At least double it, right?
Yeah, it seems ridiculous to say someone who makes like 130,000 would be a public charge, but
Well, I mean, if
they-
they have 5 kids, if some people have a lot of family, they're living in San Francisco, they're living in New York. They have health conditions, right? Some surgery is
Yeah.
really expensive. So the new memo is asking everyone to look at the complete situation. And some people in some cultures, one person makes money and they have to support an entire village, not just your nuclear family, right? So in the U.S., you might just focus on your nuclear family, but if you're coming from Jordan, well, your uncle and aunt, everybody's relying on you, right?
I see.
Yeah, it'll be really interesting to see what happens with this new public charge and how they handle that, like benefits for healthcare.
Yeah.
Because at the end of the day, you're saving someone's life sometimes just, by providing health insurance, which, I mean, it's not something that you're dependent on. It's like life situation happens. So it'll be, but it's still discretionary, right?
Yeah.
Like it's discretionary. It's up to the officer, their opinion, how they see it, how they weigh everything out.
So double and triple.
Double, triple,
Right.
yeah.
I have a friend who's here in ESTA. They want to get married. Been here for about a month and a half, but they can stay longer. Is AOS still possible? They may also have a misrep.
That's already like minus 3 points, right? 3 red flags. And in this administration, definitely a lot more difficult. As a philosophy major, I rarely ever want to say anything is impossible, right? I mean, if we're looking at all the possible universes, I'm sure there's one of them that they still could get a green card. But it is significantly more difficult compared to last year and compared to before that. And especially, it also depends on which state you're in, right? In California, the Ninth Circuit, as an ESTA holder, coming in as a visa waiver, if you get married and you file adjustment status, you are not waiving the right. Well, I mean, you are still entitled to go before an immigration judge to get a bond. Meaning, if you file the case, if ICE picks you up, they cannot just directly take you to the airport and deport you. But in other states, because you're a visa waiver holder, you came in, you waived all immigration privileges, so they could just lock you up for 6 months, a year, and then deport you. And that is really surprising for most people, but that happened to this Irish guy. So it's like, depending on which state ICE picks you up, also makes a big difference.
Interesting. So based on your experience, if advanced search of device is performed and the device is returned after 5 days, does that mean the person is fine? Otherwise, they would have held it for longer as evidence of a crime?
HSI wanted to see it. CBP takes it. I mean, CBP rarely takes things on their own volition. I mean, I've talked with them so many times about this. They are very sensitive about security because privacy. It makes them look really bad looking through phones and stuff. But if they have a high suspicion of something, then they kind of look through it. But they generally just look through it, and that's all the extent that what they're willing to do. They don't want to like really confiscate. But if they confiscate, it's almost always because HSI or different department in the government have asked them to do that. Now, returning it within 5 days is pretty quick. I've seen people, customs and HSI, hold on to it for over like 5 months or so. But yeah, I mean, if they gave it back, they found what they needed to find, and but still be prepared that you will have to go to secondary next time you come in.
I asked for an InfoPass appointment, but didn't get a response. Should I try again, or can I escalate further?
Yep.
Yeah, no, just call again. Call again. Your problem is the callback. So you need to call again. Ask again.
What's going on with ICE arrest at the airport? Is it safe to travel in person with a pending 45 and asylum at court?
That is exactly what we're talking about today. So this video will be replayed. We'll be posting it. You could see it on the live immediately, but what we try to do is we try to actually make the best content. We cut out the, not so good parts and make it a much shorter 5-7 minutes, and we'll be posting that. So if you just wait about a week, you could rewatch everything. But if you can't wait, within a few hours, you could just rewatch the first part of this segment. But now I think I have to go to the second news,
Okay.
and then we'll take some more questions. So the first news, we just spent talking about ICE detaining people with I-94 overstays, right? Even a couple days, even at airports, even at domestic airports. But the second thing we want to focus on, USCIS drilling in deep during the green card application. And you might be saying, well, that's what they're supposed to do. We just want to go through exactly kind of what's going on, because this is what we're seeing very recently in the past few months, and having a conversation with a USCIS officer about what their practice is and how it relates to AI. So first of all, in the past, these adjustment of status interviews, a lot of the questions they ask you, you answer no, they don't drill in that much more. Have you been a part of the Nazi government? No. Have you been a part of a totalitarian regime? No. Have you been a part of the Communist Party? No. Have you been a part of this and this and this? No, no, no. We take your word for it. We don't drill in that much deeper. You're married to a U.S. citizen. You could probably get a waiver. That's it, right? You might say, oh, that's too easy. Well, because USCIS always holds and reserves the card of, oh, you lied on that question. A few months later, a few years later, we discover something, you committed a crime. Now we're going to revoke your green card and we're going to deport you. That's how it used to be done, right? Give you the benefit of the doubt based on the questions, and then we could revoke it later if something happens. Now, they're not giving the benefit of the doubt anymore. So one of the first things they do, depending on what country you're from, their system, right? Let's just name some of the top countries, right? Iran, North Korea, Russia, prior USSR, Venezuela, Cuba, China. A lot of people and a lot of organizations within these countries, and then within these countries, a lot of the key organizations that people might have been part of, there's a full-on list. When the officer is interviewing someone from said country, potentially who have worked for said organizations, immediately jump in and start asking a lot more in-depth questions. And some of the questions are, when were you part of these organizations? How long have you been a part of these organizations? Why did you join? Why didn't you why didn't you go somewhere else? Was it voluntary? Was it involuntary? How old were you? AI is able to feed the government clear, updated information about every single one of these organizations. Before, they have to dig a lot more, and the officers don't have time to dig that much. So when they see the entire 45 application, they have to flip through everything and click through all these little links and go back to DS-160, how you got your visa in the first place years ago or decades ago, and match everything. It takes so much time and effort. We know a lot of USCIS officers who do this, who do their job and do this and get commemorated because it's like they found something that other officers would have missed. But it's a lot of manual work. Now with AI, instantaneous, right? You submit your application, they double check it with all other records, and immediately get fed certain questions, and they can immediately see, oh, this doesn't match. Then they start asking more. Their job now is to ask the questions. They're repeatedly trained and told, USCIS officers are repeatedly trained and told, just because you are a part of an organization, just because you are part of, doesn't mean it's definitely inadmissible. But they are charged to ask the questions. Just because you joined involuntarily doesn't mean you are free to go. Still more questions. Well, why did you join? What did you do after? How long were you part of the organization? The most devastating thing that we see, and we have seen in the past few months, is that people lie about these. It could have been fine if you just told the truth, but you try to hide it, and then it was discovered, and therefore it's misrep. And if it's a misrepresentation and it's fraud, now that in itself is an inadmissibility, right? So if you're part of an organization that might be a harm to the United States, it's an inadmissibility. So as they're drilling in deeper, depending on how you answer, you might be fined. You might have to apply for an exception. You might have to apply for a waiver. But if you lie about it and they find out, it's a guaranteed misrep and it's a guaranteed a waiver if you qualify. And then if they also discover, and this is double whammy, right? Because you lied about it, meaning you were part of it. So now they discovered you, well, maybe it was involuntary. Maybe you were young when you joined. Maybe it was decades old. Maybe you didn't know you were part of it. But because you hid it from us, now it's a misrep, right? So that's what we're seeing. They're being trained to drill in a lot deeper. They're trying to drill and find out if it's any misrepresentation. Nothing is, well, some things are guaranteed inadmissibility, but just because you were young doesn't mean you definitely get a free pass. Just because you're affiliated with a company that is a subsidiary of something else, well, do you fit one of the exceptions, right? So they go through a lot of this analysis, and that's what the officers are supposed to do now. And so when people file adjustment of status applications now, they really have to think through that and be prepared for it, because the officers are going to ask. And so if you didn't think it was going to be a problem, and then you get asked and you weren't prepared for it and you answered incorrectly, that actually might make your case worse. And we've already seen so many people got in trouble, and then now they're doing consultation. And so that's why we're reporting this.
Yeah, they are even asking about unlawful entry and how you entered, who paid for it, who came with you, was the people that were coming with you, your family members, did you assist anyone in entering the U.S. illegally, which is all related to inadmissibility.
Right.
But it had never been the case in the past, right? Like they ask, okay, how did you come in? Crossing the border, through the hills or whatnot, and like, oh, okay, then, that's okay. You already explained, but now it's like, okay, but who paid for it? And how did you pay for it? And did you have your children with you? And if so, did you help them to cross the border illegally? So it's like, it's a lot more detailed and in-depth questioning that can potentially trigger inadmissibility and then require a waiver. So not everybody qualifies for a waiver, as we know, so it's a lot harder for people to get green cards.
Right. And if you work with a group and you help somebody else that other than your kids, then suddenly that's smuggling, right? And they also ask about your unauthorized work. Well, you were unlawful here for several years. You were working. Who's your employer? How did you get the job? Maybe if it's a green card petitioning you, that's obviously one story where it's going to be very difficult. But we're seeing potentially USCIS is going to transfer that information to ICE, and then ICE is going to go to the job site, and then the job site is now going to have to pay a pretty hefty fine, right? And so that is all in the works that we're seeing happen. So now, will jobs still give you a job, right? I mean, they almost got arrested, they got busted because of you. So it becomes a lot more sensitive. And that's why you need to prepare a lot more for.
Yeah, and then family-based preference petitions, right? Like, for example, Mexico, Philippines, they have to wait 25 years sometimes to be able to adjust, right?
Yeah.
And then it's a 245I petition, so you can file the application here. But if you worked unlawfully, that may be a problem. Now, if you relied on the government, that's also a problem.
Right. If you relied on the government, then that's public charge.
Public charge.
But if you work by yourself illegally, well, then that's unauthorized work.
Employment.
You might be able to still get a green card because, your U.S. citizen petitioned you or 245I, but then they might now be able to go after the job, right? Now, a lot of people on the Republican Party says that's totally great. I talked with the congressman that passed the I-9 audit, and he's the one who championed the bill, and he's really happy about that. And he's really sad that after he did it, for the past decade, I didn't do I-9 audits as much. And so will that improve U.S. employment? It might be. That's my personal prediction. ICE is ramping up on the humanitarian front now in the sense of detaining a lot of people and deporting a lot of people, but that's only one small sliver of their job duty. Potentially the next administration, let's say it's a Democrat, they scale everything back, only deport people who have massive criminal records. Well, what's the government going to do? Are going to fire all the ICE agents? No. they're probably going to say, well, do something else instead. Well, everybody's okay with ICE agents going to businesses because if they're hiring illegal workers, maybe everybody's okay with that. And so now from now till then, the next 2-3 years, they gathered all this information. You know, these 20, 30, 50,000 businesses across the US have been hiring all these illegal people. Well, then go after them, right? And so now ICE has the records. So there's all these things that we're foreseeing in the next 5-6 years. The ramifications. We don't know what's going to happen, but we're in it day in and day out. We're seeing what's happening. We're seeing the memos. We're piecing things together, and we're talking about it. This is not conspiracy theory, right? I'm just saying what might be happening. But anyways, that is what USCIS is doing at these interviews. So when people go to these interviews, they definitely need to prepare a lot more than before.
Okay, we'll get into some more questions. I applied as Pakistani, one of the visa PAs, but I became British while waiting for my interview. So what's the best way to update my new citizenship so to avoid the pause? To let USCIS know I'm now a dual national.
Well, the tricky thing is you can only file adjustment of status based on the passport that you enter the country with. So it doesn't matter if you got your UK citizenship afterwards. Now, if you left the country and came back in as a UK national, then that the 75 country doesn't even, you know.
They're in the UK right now.
Oh, they're in the UK right now. So right. So if you come to the US with this particular passport and then you, let's say, file adjustment of status, if it's valid, then that could work. But again, May 21st memo, why don't you get your green card in the UK? Why did you come to the US to file adjustment of status, right? So you might have to overcome that.
So if they are in the UK right now, they have a not change of status. They have a green card pending in the US right now. Or they've already applied. Can they update that application to reflect the dual national?
So I'm assuming they filed the 445 before. They got the advance parole. That's how they're able to leave. Or else the 45 would have been abandoned and their green card would have been denied, right? Will be denied. So if they come back in at the interview, you could say, yeah, I'm also a UK national.
I see.
Yeah.
With the DMV erroneously registering to vote people in so many different places, how is that affecting N400?
Well, it's the same as it has always been. The USCIS officer will see it. They will challenge it. They will say, if you claim to be a U.S. citizen, you are inadmissible. Your green card could be revoked, and your citizenship will be denied. So prove to us that you didn't intentionally do it. And you have to go through the effort of taking it down, showing your voting record, showing it was an innocent mistake, showing good moral character, that you're not the type of person that would do such a thing, and hope that the USCIS officer would have good grace and approve it. Right? We've done so many cases
we've done
like that.
so many.
But that's the exact line of logic and steps to do.
Gabby, you've done these cases too?
Yes. So we actually had Irish citizen that went to apply for his driver license, was very excited to get a driver license after he got his green card. And then when it came to the time of doing citizenship, we found out he had registered because he got a ballot in the mail. And he says, I've never even, attempted to register for anything here. It was a mistake by the DMV. So how to contact the DMV, how to contact the agency that enrolled him for voting, and then get all the documentation to prove that he hadn't signed anything. And he never voted. So yeah, we were able to get him, help him get citizenship, but it was a lot of work and very stressful. He almost said, I don't really want to be here anymore. I'm gonna go back, and I don't really need even the green card. I don't want to get in trouble. I don't want to go to jail. And it's hard when you do something, you're getting acclimated to a new culture and you really don't know what to look out for. You kind of just follow the lead. If you go to the DMV and they tell you, okay, just sign here and put yes on that question. It's like, okay, I guess that's the way to go, right? So I think for new immigrants is always be very diligent in, like reading everything that you're signing, asking questions. Don't be shy. Don't follow everybody's orders, because sometimes you get into these very messy situations without even knowing that you're there. So, yeah.
Okay, update on this Pakistani national who is now a British national. They're in the UK. They have filed DS-260 doing consular processing. So they want to update that before attending the interview.
I see. I believe you just contact the embassy on it and you show them, and that will be sufficient, right? Because even, at the interview you can correct anything and everything because they have the system open. You can type, they can type it, they can redline it.
Okay, I'm one of the 20 dental technicians in America who does shade matching. Is there any waiver to do adjustment of status? They have pending asylum. They're from Syria. So this would be like a national exemption.
To do an adjustment of status. So I'm assuming you have valid status in the US now. You're extremely capable. If you are an exceptional shade matcher, you could potentially argue for EB2 NIW or EB1A. And once that gets approved, and once the priority date is current, then you can file the adjustment of status and get the green card. That's assuming you have valid status here in the US, right? Which I'm assuming you do. And then you have to continue your valid status until the priority date is current, and then you can file the adjustment of status. So look into EB2 NIW, National Interest Waiver, look into EB1A. It's definitely possible. It's not as hard as what the language reads. We do a lot of success stories on these, so you could see how other people have done it, their fact pattern, their background, and it applies to you. You could try.
And this person is, I believe they currently have an EB3 pending.
That's fine.
So have you seen any of these like national interest exemptions for this visa pause? Because is Syria one of the like 19 countries whose benefits are paused?
That's paused, but it's paused overseas. So if you're in the US, then you can do it right now. If you are overseas and you're trying to come in and you're trying to get a national interest exception, then you could do the O1. Then you can do the O1 national interest exception, come into the US to do your shade matching. And then once the EB3 priority becomes current, then you can file for the adjustment status.
I see. I have a pending AOS interview. How can I consult with you, and how much is it?
It's $250. You can book our consultation on the website. There are lots of really good people on the website that you could easily book, specific language preference. But if you only want to talk to me, then just put in the notes, I only want to talk to Joseph. Somebody will reach out to you to try to schedule my time. It's probably going to be later. So if you need a consultation fast, it's probably not going to be with me. But if you could wait a few weeks, then it's possible. But it's $250 and you could go through our website. Thank you for asking.
Okay, I want to, I always like when people ask that so you can chat it out. I want to talk about the success story today. Can you introduce it?
It's about an E2 French laundry business. So I love these because it's so bizarre and so hard. A French national wants to come to the US, and France is a treaty partner with the United States, meaning the citizens there can invest in a small business and they can get a visa. And E2 visas are almost known as the baby green card. It is almost as good as a green card. In some ways, people think it's better because you don't have worldwide taxation. And for a lot of people in Europe, well, they hate taxes even more than the US. And so if you do an E2 investment, you have a small business, you can come into US 5 years, 10 years, 15, 20, you just stay here for as long as you want, as long as your business is still there. However, it's not easy to just start any business. And what kind of business, right? So first of all, you need to prove that the business is real and operating. You need to prove that the business makes enough money so it's not marginal, meaning you're not just paying for your own salary and living, and it's like a skeleton zombie business where you're really just money goes in, money goes out. It doesn't actually contribute to the US. They want to see an actual business that is growing, that's paying taxes, that you're employing people, So it's not as big as other, requirements like EB5 or L1, but at least it's not marginal. And that you are not stealing American jobs. You are an investor, you're creating a business, and other people are doing it. You're hiring different people. So a cleaning business of this person's background, it was pretty clear that this person was not going to be the cleaner. They're not going to be there scrubbing toilets. They're not going to be there vacuuming. They are there hiring a lot of people to do it, right? Because of their background. But have they invested enough, right? So this was a little bit shy of $70,000, or just barely $70,000. What kind of business can you do with $70,000? And what did you spend it on? Because you have to spend the money too. So they spent $70,000. They bought a car, or leased a car, a few $1,000s. They bought T-shirts. They bought a banner. They have contracts. They have everything in place with all professional service for the marketing, for the mailing to the customers, having a lot of customers sign up that say they want to do it in a very popular, wealthy district in Seattle, because that's where they want to live. So in Seattle, this cleaning business, $70,000. Is it going to work? It was really, really hard. I wasn't quite sure this was going to succeed. This was Andy's team working on this E2 case. Not a lot of money, a cleaning business, very competitive. There's lots of cleaning businesses. How are you going to succeed compared to everybody else, and why, right? So, and on top of all that, another difficulty was the money was really confusing, because it was a husband transferring to another bank to another bank before it got to her. So we have to trace the source of fund before we even got to the 70,000 pool. And then once the money goes into the US bank account in Seattle, then spending it. But is that enough, right? Because we've seen E2 businesses with 200, 300,000 investment and still fail because the officer said, well, I don't think that's going to make enough money. Sorry. You're throwing the money into, I'm doing you a favor by rejecting you, because if you come to the US, your business will fail. You're going to burn more money, and then you'll be a public charge. So doing you a favor, just denying you outright. So 70,000, how is this going to thrive, right? The key where I saw that this case was able to get approved was everything just made enough sense. It was an investment in a very wealthy neighborhood with a lot of wealthy residents as well as wealthy businesses. There were competition, but the competitions are all companies with no employees, with one employee. A lot of cleaning businesses, just mom and pop going and cleaning. They are formally and one of the only professional cleaning services, with T-shirts, with white glove service, with a car, and their argument is economy of scale. By cleaning one office and then going next door and cleaning the next office, and then going next door and cleaning the next office, right? So much of the cost for cleaning is you go and clean one, and you have to drive across town to clean somewhere else, and now one day you can only clean 2 different places. But if you hire full-time employees, provide a comparable, competitive pricing and service and dedication and customer service, and businesses and wealthy people like that professionalism, and the price is about right, but they know they can count on you, and the people that they're hiring is not just going to disappear and not show up or whatever. If it's professional, if it's bonded, okay, they could sign up a lot of different people. Again, a lot of people who are doing these E2 businesses, they're not there to try to make money. They've already made their money in France. They want their status, they want the US, they want to start a business, and they're used to having cleaning services in France. They come to the US, what? You can't, there's no good cleaning services here? Everybody I have to hire is this mom and pop? What kind of United States is this, right? So the competition, they didn't have a real good competition. They have the high-end experience from France. They invested the 70,000 in all the necessities, the car, the shirts, the marketing, the contractors, the hiring services. They could show they're going to hire 30 plus people and that it could thrive. So give us a chance. The consulate gave them a chance. With that business plan, with all the contracts, with all the things, they filed it. The case got approved this year, and now they're here starting their cleaning business in Seattle. this is like the third cleaning business E2 that we've done. Now we're gonna be known for the cleaning E2 business, right? You know, we did one for Alfred, we did one for another one, like a Taiwanese high-end natural cleaning supply business, because everybody else uses, you know, 99-cent store products, but they used fresh squeezed lemon to clean the whole house, and some customers want that, right? And so, you know, the clients from Taiwan bought a bunch of, you know, unique cleaning supplies and cleaning methods, and they're able to provide that in the US. And it's like, okay, well, that kind of makes sense. So it's crazy to think that a cleaning business, E2, can work. And because it's a cleaning business, the capital expense is not that high. Why? Because cash flow is fast, right? What are you going to buy? A bunch of detergent, right? Or the cleaning supplies. And they immediately, customers pay you in cash or they pay you a credit card. And so the turnover, right? You're selling your time and your effort for cash, so it immediately makes money. If you're going to start a restaurant, you have to sink 200,000 for the remodeling, for the permits, for the alcohol license, for the, you know, for the menu, for everything, for the marketing, before the first customer comes in and orders the first dumpling. You know, like so much money has to go in. But for cleaning businesses, it's immediate. So the flyer goes out, people says, yeah, can you clean my house next Thursday? Sure. Suddenly you hire the person, they go, they clean, and it's done. So anyways, just want to share that success story, because as scary as it is, there's so many people around the world with treaty to the United States that they can apply for E2, including Mexico, right? So just want to share that success with you. We'll take some more questions before we wrap up and end today's session.
Yeah, we will take a few more questions. So, given all of this ICE at airport, is there any danger for someone who helps a friend check in at the airport but is not traveling on the flight?
What? A friend helps them check in?
Let's say go, you know, checks their bag, go helps them, you know, carry the luggage to the security
Are they
checkpoint and
even
everything.
allowed to?
So smuggling.
Okay, obviously not smuggling.
Smuggling is, well, here's the thing. A lot of people don't know there are smuggling people. If you are driving a car and there's somebody in your car and you're crossing the border, if you are entering the country in the airport and you're seeing the customs officer and your friend is right next to you and you're saying you're a party together and you're answering on their behalf and you're not saying certain things, suddenly you're representing them, and the officer could say you are attempting to smuggle somebody, or they entered with you, well, now you smuggle them in, right? So the car situation is much more common where we see Canada, Mexico. You're driving somebody in and suddenly they're undocumented or they don't have the right visa, you're attempting to smuggle. That is a severe crime, and we've seen that label be placed on many U.S. citizens, many green card holders, and a lot of people didn't know that that was a thing. Now, if you were just an Uber driver, you're going across border, you're coming in, you had no idea, that's one thing. But if it's a friend, if it's a relative, you knew. Now, that's obviously not what we're talking about. You're talking about somebody going to the airport, you're dropping them off, and then they are going to check in. So you're just driving them over.
Yeah, or specifically helping them to check in and like checking in their bags. You know, like doing maybe the self checkout.
Right. So you're
at the counter.
At the counter. So you're talking to the airline. So that is all that fine. And after the airline checks them in and puts their information, that's when the TSA gets notified. And then when the individual goes through TSA, gets on the flight, that's when ICE can potentially pick them up. But you're long gone by then, right?
But I wonder if this person, for example, like, and I don't know the situation, but I wonder if they are undocumented and they are driving their friend to the airport to help them check in their bags. Is there a possibility that they would be questioned, right? Because a lot of the questioning that you see in the news is outside the airport premises. It's not within like the airline counter. It's like when you're like driving, when you're like walking to the car to drive away.
Yeah.
So it's hard to tell.
From everything I know about the situation, ICE agents don't want to be at the front of the airport. They don't even really want to be visible in the back of the airport. But if TSA shows them there's these individuals that are undocumented or that have expired I-94s, and potentially have criminal records and whatnot. Now, the ICE officer in the private office will decide, well, I know they're going to be at gate 24B. Do we want to go and pick them up? And if they do, they go pick them up and they leave. But even that is a very public setting. They're going to be filmed. Violence might erupt. They might get injured. Somebody else might be injured. You know, they have to make a mental calculus deciding that, right? Yeah. But we're talking about checking in, that's massive public. And if you go there, that might disrupt everything and that might create chaos, right?
Okay, that is our time for today. I'm sorry we couldn't answer all the questions. If you want to contact our firm, you can always book a consultation on our website.
Thank you guys. Take care.
Thank you.
Bye.
Thank you, everyone.